come to order, please. First item of business would be requests for bill introductions. Do we have any requests today? Seeing none, we will move on to our first item of business. Hearing on House Bill 2272. And I would turn to the revisor's office for an overview of 2272, please.
Thank you, Mr. Chairman. House Bill 2272 would provide for the escrowing of certain taxes paid under protest and providing notice by the county appraiser to other taxing entities within the jurisdiction. Section 1, the county appraiser is required to provide to the county clerk by June 1 of each year the certified list of all real properties that are protesting the valuation or assessment, and such properties are appraised greater than $40,000 and seeking an exemption from the property taxes. The clerk shall provide this list to each taxing jurisdiction potentially impacted in the county. Second section, the county treasurer is required to provide before January 10, to each taxing jurisdiction a certified list of all real properties that have tax dollars escrowed, which falls into Section 3. Under Section 3, the county treasurer shall place in a trust account in escrow and shall not distribute the portion of taxes exceeding the prior year's taxes for a property until final appeal. If the amount of tax on the residential property exceeds the prior year by $500 or more, or for commercial or industrial machinery and equipment, property exceeds the prior year by $5,000 or more. The escrow provision does not apply to newly constructed structures unless the appraisal exceeds the building permit costs by 115%. And with that, I'd be happy to stand for any questions.
Thank you. Committee, any questions for the revisor's office? Seeing none, thank you for that overview. And at this time, I would turn to Department of Revenue if they would wish to address the fiscal note.
Mr. Chairman and members of the committee, Kathleen Smith with the Kansas Department of Revenue. There is no fiscal impact due to House Bill 2272. It may have the potential to delay the distribution of property taxes collected from certain properties, but that's it at this point. With that, I would stand for questions.
Okay, thank you. Committee, any questions for Department of Revenue? Is there anything, Kathleen, regarding property valuation division that this would impact as far as state assessed properties? Or how are appeals handled? How are the appeals handled with state assessed?
Mr. Chairman, I would have to ask PVD that question, and I don't believe they are on at this point. So I could get back with them regarding that question.
Okay, thank you. Committee, any further questions? Seeing none, we will move on to the proponent section of our testimony, and we would like to welcome first to committee Randy Stuckey, representing several different organizations: Kansas Grain and Feed Association, Kansas Agribusiness Retailers Associations, Renew Kansas Biofuels Association. Welcome to committee.
Thank you, Mr. Chairman. Members of the committee, good afternoon. I do represent the three different associations, and so this afternoon we want to bring testimony in support of this bill that has been in one form or another heard by this committee over the last, I think, 2 years. This is an important issue for all of those industries that were just mentioned. The biofuels processing facilities in the state of Kansas, the grain elevator industry in the state of Kansas, and the ag retailers, all of whom have complex properties and collectively pay millions of dollars in property taxes every year. And our members are good public stewards. They're good corporate citizens. We don't mind paying into property taxes that help support local government and schools. But as this committee in previous years, recent years, has heard, the grain and ethanol industries have experienced burgeoning valuation increases on their facilities. These are large, complex facilities, and so when the valuations increase, they certainly do appeal when necessary. And that's why this bill specifically is important to my members, because those appeals, when they happen to the Board of Tax Appeals or beyond to the District Court, the Court of Appeals, this is a lengthy process. And when we're dealing with very large increases in very large property valuations and tax bills, it's important to our members that when they do win those valuation appeals, that those monies are appropriately returned to my members. And the reason I say that is because I've heard in testimony before this committee and others where a local unit of government will say, well, if this taxpayer wins their appeal, it's going to injure our local unit of government, our school board, X number of dollars. That is never an appropriate argument to make. The reason is because those dollars should have never been budgeted to begin with. Whether or not a taxpayer wins their appeal before the Board of Tax Appeals or the District Court should always be made on the merits. The decision should be made on the merits of the argument, not on the final effect on the local unit of government. This bill answers that question. It says, during an appeal of a large valuation increase, those tax dollars that are paid under protest, will be escrowed, not budgeted by the local unit of government or the school board, until such time as the final appeal has been made, until final litigation, final resolution of the litigation. That is an entirely appropriate. For that reason, this is a great policy for the state of Kansas, both for the local units of government and the taxpayer. It's good policy, it's reasonable because of the amounts that we're dealing with. It's not every taxpayer, it's those taxpayers that are increased above a certain threshold, and only if they appeal their valuation. So this bill, like I said, it's been heard by this committee a couple of times. It didn't get passed last year for various reasons, but I think this time has its due, and I hope the committee looks upon it favorably. We'd certainly stand for any questions at the appropriate time.
Thank you. Committee, any questions? Representative Sanders?
Thank you, Mr. Chairman. What generally is the time from the initial appeal to the final appeal? And are there interceding steps from initial appeal to final appeal?
So in my experience, and I can only speak from the experience of myself and my members in their appeals before the Board of Tax Appeals, your initial appeal is informally with the local units of government. So it's that process. There's a timeline built into that process, and then you appeal. If you can't find resolution there in the 4 to 6 months time frame, then you can make your initial formal appeal to the Board of Tax Appeals, and that hearing can be set out 9 months, a year, depending on the backlog of the Board of Tax Appeals. Then you await your decision from the Board of Tax Appeals, and there was a bill that was passed in recent years that shortened that time frame, I believe. But then if you don't find resolution as a taxpayer from the Board of Tax Appeals, you have two avenues from there. Even you can appeal de novo to the District Court, which means on the facts, a new hearing. And that time frame is dependent upon the availability of the District Court. Or you can appeal to the Court of Appeals on the record, on the cold record, from the Board of Tax Appeals. And again, it's based upon the availability and time frame for the Court of Appeals. So we're talking about collectively a couple of years period here. Yep.
Thank you.
Representative Baker?
Thank you, Mr. Chairman. Thank you, Randy. Excellent job. So from experience, the time frame on that is usually 3 to 5 years. And because we had a gentleman in last year at committee from Wyandotte County down the Fairfax district that gave some real compelling testimony on that. The bottom line, I guess, is when the government owes you money, there shouldn't be a perpetual case, because that's what you have to do, is perpetually stay in protest. You just protest every year, and if the courts rule against them, they pay back 1 year. So you're perpetually in I know cases that have been in court for 9 years. So, yeah, it's not a good deal.
Representative Corbett?
Thank you. I've listened to your story, and I kind of agree with you. We heard something last week, you remember, where we were talking about if you lock their doors and take their taxes, the big complaint then was, well, how are we ever going to get that money back? How are we ever going to draw that money back from where it went to? And same scenario should work here. I mean, it's the taxpayers' dollars till it's determined where it goes, and it should be kept in a safe place for both of them, so we don't have to worry about who's going to find the money when it's needed. So I think it's a good bill.
Representative Helgerson?
Thank you. I wanted to talk a little bit about the logistics. You appeal this, and did I hear you say it sometimes takes 3 to 5 years to go through the process?
It wasn't my testimony, but that was.
Okay. If you appeal or pay under protest, it'll take at least a year into the next cycle. So the next cycle, you've gotten higher valuations. So if you are successful, you have to protest the second year, and there's no guarantee then that you get any protection, because the Supreme Court has said that it used to be, I think, 3 years without an increase in valuation, but they've changed that now. Do you also advocate that maybe we should have a statutory opportunity for people to get 2 years rather than the 3, if it can be worded that way? Do you understand my question?
So the stay for 2 years, is that the?
Have the stay. You get a stay for 2 years. You get the year that you're protesting if you are successful, and then you also get a second year that you don't have to protest, and that stays the same. Otherwise, I agree, you're in continual mode of appealing every year because they keep increasing it, and you never have a chance to come up with the correct valuation.
Right. Now, we were certainly in support of that bill that was last year or the year before that would have done just that. It would have stayed your increase for 2 years because you appeal every year, and you're just in this endless cycle of evaluation increase and appeal and increase. Even if you win, there could be an increase that next year to appeal. And this is the endless and costly appeal process that does not work. It is not working, but that's what we're dealing with.
Okay, thank you.
If I could follow along that line of the question, though, this bill doesn't really address the appeal process. It just essentially escrows that money.
Right.
So my question is, the process is still going to move along. Are there anything, and other proponents can address this as well, but is there anything we can do the appeals process to improve that? That's my first question. The second question is, the money, you testified that, there's some arguments in court that, well, we can't pay this back because it would just damage local units of government too much. Have any of your members ever been successful in the appeal process and not gotten paid the full amount?
No, I don't believe that would happen. I mean, it's on the public record. You'd have a judicial order saying, pay these people back, but the case remains that those arguments are inappropriate, but they have been made. And if those arguments sway then the decision makers, and these are people that are making these decisions on what's appropriate in valuation, that is entirely inappropriate. And I think we've even looked at some legislation to prohibit those types of arguments. They're really unethical because it doesn't go to the merits of the argument. It just says, look at what's going to happen to our budgeting process if we have to repay these monies that we shouldn't have budgeted to begin with.
Oh, I'd agree. And I think that would be up to the judge to make that determination for sure. I was just curious if there were any entities that hadn't been made whole if they had been successful in the appeal process.
Not that I'm aware, no.
I think Representative Baker wanted to make a comment.
I'm a victim. I've been in 9 years in an appeal, and I appeal every year, and I usually get the county loses, the courts rule against them after we get all the way to the Court of Appeals, and it's 3 to 5 years out, and so we get paid back 1 year. We're perpetually in court, and we're not asking to escrow. This bill doesn't escrow the entire. It's just the increase, and when we talked to the appraisers and the treasurers, we made adjustments to address their concerns. The number of people that are impacted by this is very, very small. But with the changing valuations in today's economy, taxpayers need some protection, and that's kind of what this bill does.
Chairman, that's a great point that he made. That's why it's reasonable. It is not escrowing the entire payment in protest. It's just the increase that's being fought over.
Right, and I guess that's the essence of my question is, I understand in Representative Baker's instance where he got paid back 1 year, was that the court order? I'm just curious, by escrowing this money, have we ever had someone that refused to pay the protest money back to be made whole, that they would basically be able to use all this escrow money and say, okay, we've got it, here it is? Have they ever said, we don't have it, we can't pay it?
Well, and I don't know if anybody's not gotten paid, but often it's more than 1 year. And so it's the compound of this year and then repealing these 2 years. So the dollars do add up, and that's why it's important.
Okay. Any further questions for this conferee? Seeing none in the room and none online, thank you for your testimony.
Thank you, Chairman.
I'd like to welcome to committee our next proponent, Eric Stafford with the Kansas Chamber. Long time no see.
Thank you, Mr. Chairman and committee members. I'm trying to find some information here that might be helpful, and I'm not able to pull it up on my phone fast enough. Thank you for the opportunity to be here today. Eric Stafford with the Kansas Chamber of Commerce in support of House Bill 2272. Randy did a good job summarizing the bill and the issues that are in front of us. In my written comments, I mentioned we do have one member who is under appeal for multiple properties in Johnson County. That appeal is going to the Supreme Court. No dates for argument. The Court of Appeals decision just came out in the second half of 2020 for tax year 2016 valuation increases. But that is, Randy's exactly right. That's the exact argument that's being made. Well, if this taxpayer is successful in their appeal of their 108% increase in their valuation of their properties, then it's going to be disastrous for our county, and residential property taxpayers are going to be left to foot the bill. Whether they're leaving the impression that, Walmart's taking money away, or our member is taking money away. And I'll say, I just mentioned one company, there's 56 big box retail properties in Johnson County that are all under appeal for tax year 2016. And that's because collectively there is a 110% increase in valuations for those big box retailers. There's a case that's currently waiting decision for Hollywood Casino in Wyandotte County before the Supreme Court. Same thing, same tax year. So there are many cases that are out there right now dealing with 1 year valuation, but we're 5 years in. And we haven't had oral arguments yet before the Supreme Court, so that's still coming. To your question, Representative, there was a bill in 2015 passed by the Legislature dealing with property taxes appeals, the Board of Tax Appeals. One of those provisions said that if a taxpayer is successful in their appeal, the local unit of government cannot go back and increase their valuation the following year to prevent a spike. Say, okay, well, we didn't get you this year, we're going to come back and get you the next year. The Supreme Court deemed that provision unconstitutional because it wasn't treating properties fair and equal. We disagree. Justice Stegall dissented in that opinion, saying it's not creating an unlevel playing field or treating properties differently. It's just treating properties that were successful in their appeal from facing a spike. But that's the decision from the Supreme Court. So that provision is no longer in effect, which leaves us kind of saying, well, how do we address this issue? I think the chairman's right. This bill does not address the appeals process. We'd be open to working with parties to try to find a solution to that. But that is a real life issue that our members are facing on a big scale. We're talking millions of dollars. I was trying to get an exact dollar amount of what the impact would be to the budget, not the valuation, but the actual dollars for the properties under appeal. I don't have that answer yet, but it's significant. It's significant to that taxpayer. I'd say in the whole scheme of the county budget, that's probably, I think Johnson County's budget is $400 or $500 million. it's not that significant, I think, in the whole scheme of things. But to that one taxpayer, I think you're talking millions. Yeah, I'll be happy to stand for questions. Like I said, Randy did a great job summarizing the bill. I feel like it's a pretty common sense bill that, you know, for those properties under appeal, put that money aside. It should not be put into the budget. There were some problems with the original bill, and I think that if I remember right, that this version, you know, I think they're going to be speaking later, but we worked out some concerns that other parties had representing government bodies. You know, we would just ask for your support. I think this is a good final product, and be happy to answer any questions you might have.
Thank you. Committee, any questions? If not, I have one. I know that some of the numbers are different in this bill. Perhaps you or perhaps Representative Baker could address the reasoning or the methodology that went into selecting the limitations or the thresholds.
I'd probably defer to Representative Baker, if you don't mind. I know we weren't, they're not ideal in our view in terms of the levels that have to be met, especially on the commercial property. But art of compromise, you don't always get what you want. So, but I'd probably defer to Representative Baker on that.
Okay. Chair recognizes Representative Baker.
Thank you, Mr. Chairman. Thank you, Eric. Great job. So on a residential property, that $500, I think in Ellis County, that would have to be an increase in your appraised value of like $60,000 or $80,000 on your house. Depends on your mill levy in your county and where you're at. On the commercial property, you know, you're looking at probably $150,000, $200,000 increase. The appraisers, when we talked to them, that was a number they were amicable with because most appraisers can get it that close. And then we exempted the new construction and classification changes, all those kinds of things. We tried to address their heartburn on that. So that's kind of how those numbers came to be. I mean, surely you can get within $50,000, hopefully.
Okay, I'm just curious where the methodology came from. Committee, any questions for this conferee? Seeing none, thank you for your testimony, Eric.
Thank you.
Committee, I'd also direct your attention to written-only testimony, proponents from Mark Toome, Kansas Association of Realtors, and Shahira Stafford, Kansas Cooperative Council. Is there anyone else wishing to appear as a proponent for House Bill 2272? Seeing none, we will move on to opponent testimony and welcome to committee Jay Hall with the Kansas Association of Counties. He will be joining us via WebEx.
Yes, thank you, Representative Smith and members of the committee. You have my testimony, and in it I address some of the concerns that KAC has with this particular bill. Obviously, KAC, we understand the issues that are facing taxpayers, but given what we presume the likely passage of Senate Bill 13 and the budgeting changes that are coming as a result of that legislation, we are hesitant on this bill because we don't know how that bill is going to affect county budgets. And part of that, you've already heard some discussion about whether or not the money from an appealed property should be included in the taxes. And if we take those funds out, essentially we're going to have to adjust the mill levy at the county level in order to make up those funds, because again, you're removing that portion, and so you'd have to adjust the mill levy as necessary to get to your budgetary amount. And that's really our concern, is that you're going to have to make adjustments somewhere to account for that money that's in escrow in order to make the county budget work number wise. Because it's not just well, you just set this money aside. It's because essentially counties aren't budgeting for additional funds to then set aside money in escrow. And so they would have to simply escrow those funds at the front end and then make their budget work with an additional mill levy on the other taxpayers, essentially. But our main concern is just, again, with Senate Bill 13 coming, we want to see where that's going to take us with the budgeting and those issues prior to putting this new legislation in place. I'd also like to briefly address the appeals process. And our concern is that, as you've heard, this process can take some time, and really the county doesn't have a lot of control on how long that process takes. And this bill doesn't really address that. So if the concern is the length of time that the process takes, I don't know that this bill really addresses that. And with those comments, I'd be happy to answer any questions that the committee may have.
Jay, I have a question. You start off talking about budget, but in reality, the valuation process and the appraisal process is separate from the budgeting process. And in essence, if that money, or if that abatement, that protest does go through, the county, the local government will have to end up abating those taxes in the end anyway.
That's
So
correct.
it essentially does hit the budget eventually.
Yes.
So to me, it seems like it's kind of a zero-sum game in the end.
Essentially, you're correct that it would be a zero-sum game, whether you escrow it now or escrow it on the back end. We hope that our appraisers are close enough and on the numbers that it doesn't amount to a lot of dollar amount on that. But again, you never know. Sometimes things happen during the appeals process that show that those numbers are not as close as we would have hoped.
Committee, any questions? Seeing none in the room and none online. Jay, thank you for your testimony.
Thank you.
Committee, I'd also draw your attention to opponent written-only testimony from Thomas Franzen, Johnson County Treasurer, and April Hall, Kansas County Treasurers Association. Is there anyone else wishing to appear as an opponent to House Bill 2272? If not, we will close that portion of the hearing and open up neutral testimony. I'd like to recognize Trey Cocking with League of Municipalities, Kansas Municipalities. Also, long time no see.
Thank you, Mr. Chairman, for having me back once again. I really want to thank the proponents of this bill for working with us over the years on this bill. There's a lot we really like in this bill. I don't know if folks realize, but cities are not involved in the appraisal process whatsoever. So when a bill does finally get settled, and if it is a win for the taxpayer, we get a notice from the county saying, oh, we need $5,000 back. And, that can be pretty painful for a city to have to cough up. So we are thankful for the notification process in this bill. Really, the only concern we have is if a city is trying to do the right thing under Senate Bill 13, trying not to have a hearing, now they're going to face less revenue potentially because that money is escrowed. So we would ask either this be excluded from Senate Bill 13, the money that's in escrowed, since that money is not available, it be treated like a delinquent tax or something to that effect, or, the city can have their portion since they're not part of the dispute. Either way, that would help us out. But really, we thank the proponents for working on this bill. It's a fairly good bill, which really just a concern coming from Senate Bill 13.
Committee, any questions for Mr. Cocking? Seeing none, thank you for your testimony.
That was easy. Thank you.
We'd also like to recognize neutral testimony from Michael Koss, City of Overland Park. Michael, are you with us today? If not, we will consider that written testimony. Is there anyone else wishing to appear on behalf of 2272? Seeing none, we will close the hearing on House Bill 2272 and open the hearing on House Bill 2315. And I would turn to the revisor's office for an overview, please.
Thank you, Mr. Chairman. House Bill 2315 provides for the higher education deferred maintenance tax credit for contributions to a technical college for capital improvements, deferred maintenance, or the purchase of technology or equipment. Essentially, a tax credit would be available to contributions to the technical colleges for such items, and the credit would be used to offset either income tax, premium or privilege fees, or the privilege tax. The credit would be applicable for tax years 21 through 2025, and the credit would be a refundable credit. There are some limitations on the amount of credit, kind of three of them. The first one would be that not more than $500,000 per taxpayer per year, not more than $500,000 worth of credit to a single technical college per year, and not more than $3,500,000 in total credits in any 1 year for the credit total amount. And with that, I'd be happy to stand for any questions.
Thank you, Mr. Siebers. Committee, any questions for the reviser? Seeing none, we will move on to the Department of Revenue fiscal note.
Mr. Chairman and members of the committee, Kathleen Smith with the Department of Revenue. We are estimating that House Bill 2315 would decrease state general fund revenues by $3.5 million in fiscal year 2022. This is based upon, it is a 100% tax credit, so we're making the assumption that it would all be awarded and used. So we went with a cap of 3.5 million.
Thank you. Committee, any questions? Kathleen, I had one on the second page of the fiscal note. It talks about the prior higher education deferred maintenance tax credit that I believe expired in 2012. Was that just a 50% credit? Or do you know?
For technical colleges and community colleges, it was a 60% tax credit. It was 50% for the universities.
I see. Okay. Committee, any further questions for Department of Revenue? Seeing none, thank you, Kathleen. We appreciate your. Okay. We will open up the proponent testimony now and welcome to committee Heather Morgan with the Kansas Association of Community College Trustees. Welcome to committee.
Thank you, Mr. Chairman. I try not to come to House Tax, quite honestly. So thank you for welcoming me here. I stand in favor of House Bill 2315 and request an amendment to also include the 19 Kansas community colleges. Kansas community colleges provide 70% of the technical education in Kansas. And while we have local taxing authority, our local boards of trustees work very hard to keep the local mill levy as low as possible. Each county that has a community college, which we have one that has two, Montgomery County has both Independence and Coffeyville Community College, has a local mill levy to support the college. This tax credit would be very advantageous to our colleges for two reasons. One, our workforce development partners, the Kansas businesses, expect us to be training students on the most up-to-date equipment and technology that they're going to be using when they go into business. That technology is expensive. The funding for capital outlay for the state of Kansas has not increased since the 1970s. So we really have to figure out a way to keep our equipment the most up-to-date as possible with limited funds and budgets. We have a lot of industry partnerships. We believe we could have more industry partnerships should they be able to take advantage of this tax credit. The other thing about the way community colleges are funding, that local mill levy is only in the county where the college is located. But our community college system, we touch over 100,000 Kansans every year through our programs, through both our normal community college programs, our technical programs, and then also our continuing education. And this would allow the other 86 counties and businesses there to kind of participate in some of our funding. If the 19 community colleges were included, obviously that would impact the fiscal note using the methodology that Kathleen explained. If community colleges were added, it would add about $9.5 million to the fiscal note. And I'm happy to stand for questions.
Thank you. Committee, any questions? Representative Kelly.
Thank you, Mr. Chair. And do you know, Heather, whether there's a reason it's 100% compared to 60 and 50% tax credits for others?
I don't know. I wasn't involved in the drafting of the bill. In talking with our presidents last Friday, I meet with all of them weekly since COVID has started. Any tax credit that could help businesses provide some equipment or building improvements, because honestly, when you get a lot of these large pieces of equipment, it costs a lot of money to get the electrical system upgraded to run the pieces of equipment. Anything would be a help, so.
Heather, do you know approximately, and I know there's obviously 19 different colleges across the state, on average, how much funding do they get from their property taxes? Because that's one thing that I know technical colleges don't have that silo to put in place a mill levy for property taxes. So I'm just curious.
I don't know off the top of my head, but I could probably calculate really quickly during the next conferee.
Well, I know you have in your testimony, you had 36% of county appropriations. Is that what you're referring to?
That's what so of all the total community college funding, 36% of our funding comes from that local mill levy.
Okay. All right, committee, any further questions? Seeing none, thank you for your testimony.
Thank you.
I'd like to welcome our second proponent to committee, Jim Gennant, and I apologize if I mispronounced that, with Manhattan Technical College. Welcome to committee, sir.
Good afternoon. I'm getting old. I gotta remember where I put these. I do represent the 7 technical colleges. I am the president and CEO of Manhattan Area Technical College. And I appreciate the chance to talk about this bill with you. As has been mentioned, none of the 7 tech colleges have taxing authority, and yet our return on investment is fast, and it's a multiplier effect that's almost unheard of in higher education. If we were totally funded the way the formula says in the state, the tech colleges would get 2/3 of their funding from the state, 1/3 from the students. The reality is the opposite. At Manhattan Tech, I get about 28% of my funding from state appropriations. My students pay the rest. And that's just on the tuition and fees and general operating. When it comes to capital outlay, the message is worse. So the year I graduated high school is when the first capital outlay appropriation was made. That was before the movie Star Wars came out. Okay? We're all admitting my age right now. And as has been mentioned, it was funded originally at $2 million. Right now it's at $2.5 million. Adjusted for inflation, that amount should be $11 million. At my college, we get about $170,000 a year from the state for capital outlay. Pardon me, but that's criminal, especially when we don't have taxing authority. In our testimony, if you look at pages 2 and 3 in particular, you'll see some of the performance of the tech colleges. Each of our institutions had an economic impact study done in the winter of 2017-18. And you'll see on the bottom of page 2 and over into page 3, the economic impact we have on our communities and overall. No doubt Wichita Tech skews our numbers. They're the big dog the rest of us chase. The total funding to the technical colleges from the state is just over $21.5 million. The annual economic impact of the 7 technical colleges is $380 million per year, 17 times what we get in appropriations. A little over a year ago, Georgetown University released the first comprehensive return on investment analysis of 4,500 colleges and universities in the nation. One of their metrics was called net present value over 40 years. What's the value of your education over your work career? Top 5 public colleges and universities in the state of Kansas for net present value over 40 years are halfway down on page 3. Washburn Tech was number 1, KU number 2, K-State 3, Manhattan Tech 4, North Central Tech 5. 3 of the top 5 technical colleges. The difference between Manhattan Tech and K-State over 40 years was $4,000. I'm not knocking the universities. I'm pleading the case for more help for the technical colleges because of our impact. For instance, at my college, 60% of my graduates stay in Riley, Geary, and Potawatomi counties as employees, as taxpayers, and as consumers. The ripple effect of our economic impact beyond what we do in terms of occupations is amazing. Through the pandemic, we've been open again. Almost all the tech colleges opened in last May or June. We are turning out essential workers every day. Our job placement rate remains at 95% or higher. I have one of the 2 electric lineman programs in the state. It's a 1-year certificate program. When those students graduate with that lineman certificate, not even a degree, just a certificate, their starting pay is usually between $70,000 and $80,000 a year for 1 year of college. And it's those folks that are keeping your power on when the storms come through. We have grown in enrollment. If you take out the anomaly of COVID, we were the fastest growing sector of enrollment in the state higher education. We have done a lot with the high schools, and they want more. Recently, Manhattan Tech expanded to its first off-campus center in Representative Highland's community of Wamego. We get no help with that other than what money we raise and what money we produce in revenue. But we have 4 school districts saying, we need you here so we can send our students to you. Right now, I'm working with the superintendent in Manhattan to convert the 9th grade center over the next 2 years into a career academy. But we need some investment. This tax credit would help us find donors through the enticement of both of what we do in the tax credit, but it is also building a donor base for each of the tech colleges for moving forward. We're certainly not opposed to the community colleges having part of this. What I would ask is your consideration not to dilute what we need. They do get taxing authority, and it's a little over $200 million a year in what they get. We get nothing. We don't need fancy facilities. We need Butler buildings. We need the ability to have a facility that will hold up as we teach people how to use a saw, how to change oil, how we do healthcare. With most of our own facilities, we do our own renovations. Oftentimes those are student projects where they demonstrate their skills and they help save us some money. But I think you'll agree that the best bang for the buck in this state is tech ed, and the demand is growing. Thank you. I'd be glad to answer any questions.
Thank you. Committee, any questions? Representative Highland.
Thank you for the presentation. Very good. I was interested, you said you're opening up a facility over in Wamego. What kind of training will you be doing there?
Right now, we are offering general education while we finish renovating the 2 shop buildings on the property. We will start CNA and EMT training this spring. Then we'll be adding in information networking technology, then automotive tech, then welding and construction trades. And that will take about the next 18 months to do.
Thank you for that.
Representative Gartner.
Thank you, Mr. Chairman. Thank you, Jim, for being here. Washburn Tech is in my district, and I've been through and toured Washburn Tech, and you all do a marvelous job. It's just fantastic, and I'm a big supporter of tech schools. But my question is, and I'm not sure reading this bill and looking at this bill, but if a donor such as Burlington, Northern Santa Fe, came to you and said, I'm going to give you a diesel engine for a curriculum, I guess, would that be covered under this bill? Would Burlington, Northern Santa Fe, because they donated equipment to you, be able to get a tax credit at the state level?
The bill proposes it has to be a cash donation, not in kind.
That's sort of my concern, I guess. I don't know why it wouldn't, if a company's going to donate major equipment to you all, why wouldn't they also be available to get the tax credit, I guess?
One of the risks with that, almost all of our institutions do have our own 501c3 foundations. but the foundation cannot assess the value. That violates the 501c3 status with the IRS. So we can't assess the value. It has to come from a third party. And that's part of the trick in providing the tax credit for the in-kind. We can't make that valuation.
Mr. Chairman, so so you would have to get an expert to come in and make that evaluation?
We cannot do that as far as our foundations and their 501c3. Generally, the donor takes the receipt, that acknowledgement that we accepted it, and they work through their tax professional or their tax attorney.
And comes up with a value.
Right, but we can't have anything to do with that value.
All right, thank you.
Any further questions, committee? If not, I just wanted to ask, this has a 5-year sunset on it. Is this something that you anticipate the need would be met at the end of the 5 years, or was that just that was put in place to give it an expiration?
It's put in place to give it an expiration. Also, if we're as successful as we think we would come back and tell you the success story and hopefully get it extended in some way or see what other assistance we could get from the state. But we want to prove what we can do with it. And again, what I said earlier, it allows us to build up a donor base that hopefully we could then tap into on a regular basis, regardless of the tax credit component.
Representative Kelly.
Thank you, Mr. Chair, and maybe you'd be the good one to ask, since it seems like you were involved in it. Why 100% tax credit and not 60, 70, where most of the ones I've seen are?
Right. For us, without having the taxing authority, we'd like the maximum impact as we work with the donors for these kind of projects. That's the simple logic behind the request.
That brings up another question I had. You referenced your age when you first came up here. Were you in place when they had the previous?
I was with a different institution in the state.
Okay.
And in my opinion, I was at a different position, different institution. While that program had some success, it didn't have as much success as we believe we would have with the tech colleges because of that connection to business industry and that return that we show.
You know, and if you don't have this answer, perhaps we could look to the reviser or Department of Revenue for an answer, but do you know if that program had limitations on it as far as this one has a $3.5 million statewide, $500,000 per college?
If I remember correctly, the previous one was maxed out at $200,000 per year for the 2-year colleges. I'm not sure about the universities.
Okay. We might get that information for the committee to consider. Any further questions, committee? Seeing none, thank you for your testimony, and may the force be with you. Committee, I'd like to draw your attention to written-only proponent testimony from Dr. Jerry Farley, president of Washburn University. Is there anyone else wishing to appear as an opponent or proponent for House Bill 2315? Seeing none, committee, I show no neutral or opposing testimony. Is there anyone else wishing to appear on behalf of 2315? Seeing none, we will close the hearing on House Bill 2315. And we do have a few moments. Committee, I would like to work Senate Bill 21. This is the sales tax authority for Cherokee County. And while you are all retrieving your documents, I would turn to the reviser for an overview on Senate Bill 21.
Thank you, Mr. Chairman. Senate Bill 21 would validate the result of an election, held on November 3rd, 2020 in Cherokee County. This election had a question submitted by the Board of County Commissioners to increase the county-wide retailer sales tax by 0.5%, essentially continue the prior one by 0.5%. However, the revenue received by the county would be expended solely for the purpose of financing ambulance services, renovations and maintenance of county buildings and facilities, or any other projects the county deemed necessary by the governing body of Cherokee County. Accordingly, the sales tax would terminate prior to January 1 of 2033. Again, section 2 of the bill would allow the county commissioners of Cherokee County to set this rate increase by 25%, and the bill would take effect in publication in the Kansas Register. And with that, I'd be happy to stand for any questions.
Thank you. Committee, any questions? Seeing none, thank you for that overview, Adam. Committee, what are your wishes with Senate Bill 21? Chair recognizes Representative Kelly.
Thank you, Mr. Chair. I would move that we pass out Senate Bill 21 favorably.
Thank you. And a second by Representative Helgerson. Any discussion on Senate Bill 21? Representative Highland.
Thank you, Mr. Chairman. I will be voting for this bill, but I would publicly state that I am opposed to this kind of behavior by counties having elections before they've come to the legislature for approval. But it happened, and I'll be voting for it. Thank you.
Any further discussion, committee? Seeing none, Representative Kelly, you may close.
Thank you, Mr. Chair. I close.
Thank you. Committee, you've heard the motion by Representative Kelly to pass Senate Bill 21 favorably. All those in favor, please signify by saying aye.
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 Any opposed? Here's, we have somebody that needs muted here. You always hear voices. Any opposed? Seeing none, motion passes. Senate Bill 21 is recommended for passage. Committee, that concludes our agenda for today.